So we need to talk about what is going on in the current assault weapon ban challenge that is set to be considered by the Supreme Court before the end of this year. Now, really quick before we jump into this video, I want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all my viewers are actually not subscribed to the channel. So if you watch this channel, if you enjoyed this content, please consider subscribing. Also, make sure you hit the notification bell and turn on all notifications because that helps to ensure that YouTube will actually send you these videos. And then also, I'm going to leave a link down below. It's for our newsletter. If you guys want to have more contact with me and get more information from me, sign up for the newsletter, and we're going to be doing some really cool things also over there. As I mentioned in the intro, in this video, we're going to be talking about a very important case. It's a challenge to a state's ban on so-called assault weapons. And currently, this case is seeking Supreme Court review, and it's set to be considered before the end of this year. In this video, we will be discussing the Maryland assault weapon ban case, Bianchi versus Brown, which is now Snope versus Brown, so that's how I'm going to refer to it. This case has now for the second time made its way in front of the Supreme Court, and now it's positioned to actually be considered by the Supreme Court before the end of this year. However, the state and the anti-gunners are trying everything within their power to actually stall this case out, and now they are arguing in their brief that the rifle ban case should not even be reviewed by the Supreme Court, that it does not violate the Second Amendment, and therefore the cert here should be denied by the Supreme Court. Now, for those not aware, this case involves the state of Maryland and their law in place there that bans certain rifles as so-called assault weapons. They also have a magazine ban, and so they are restricting the access to certain arms. This ban was challenged in a Maryland federal district court. However, the case was ultimately dismissed by that lower court, and that was because the court there found that there was already a precedent in the Fourth Circuit from an en banc panel in the Fourth Circuit in a case called Colby that already had upheld the rifle ban in Maryland, saying that it was constitutional, but that was under the prior Supreme Court guidance in the Heller case, and that was during a period when the Supreme Court was not active on the Second Amendment at all. So the lower court dismissed this case originally, and then it was appealed up to the Fourth Circuit in front of a three-judge panel. The three-judge panel again dismissed the case, upheld the dismissal, finding that the precedent in the Fourth Circuit was controlling on this. They didn't need to review this. And then that led for the first time for this case to make its way to the Supreme Court, seeking Supreme Court review. This case was then put on hold at the Supreme Court level because the Supreme Court had granted review to the Bruen case and was set to actually decide in the Bruen case, and that was back in 2022. Now, as we all know, ultimately the Supreme Court did issue a decision in Bruen. They reaffirmed that text, history, and tradition is the appropriate analysis when you're looking at Second Amendment cases. And as a result of that, after issuing Bruen, this case was then GVR'd, meaning it was granted, vacated, and remanded back down to the Fourth Circuit for a new decision, a new analysis, and a new ruling in light of what the Supreme Court said in Bruen. This case then was opened back up at the Fourth Circuit level, but then this case sat dormant. No decision was issued for 13 months. Then suddenly out of nowhere, the Fourth Circuit en banc panel said, we're going to take this case out of the hands of the three-judge panel, and that was really done because the Fourth Circuit en banc panel did not want a pro to a decision to be issued by that three-judge panel. Now, ultimately, the Fourth Circuit en banc panel did rule in this case, and once again, they upheld this Maryland rifle ban, finding that it was consistent with the Second Amendment, that it did not change at all because of Bruen, and ultimately they found that these types of rifles within the state of Maryland are militaristic, they are military weapons, and therefore they can be banned. In the decision, the majority of the Fourth Circuit en banc panel stated that the assault weapons at issue fall outside the ambit of protection offered by the Second Amendment because in essence, they are military-style weapons designed for sustained combat operations that are ill-suited and disproportionate to the need for self-defense. They also went on to argue that the Bruen analysis did not disrupt what they said at all prior in the Colby case, and there were some dissents from judges like Richardson, Niemeyer, Agee, and Quattlebaum, and also Rushing, who simply said that their other colleagues in the Fourth Circuit were just fudging their analysis. They were not going to faithfully apply Bruen. They were not actually looking at the text of the Second Amendment or the history or tradition surrounding it. They were simply just reaching the decision that they wanted. That Fourth Circuit decision was not shocking, but now this case is teed up for a final merits review to go to the Supreme Court and for the Supreme Court to finally have to address this issue. Initially, the state of Maryland was trying to stall this case out by asking for multiple extensions. They did not want to respond to the petition before the end of this year. And ultimately, I think in my mind, the goal was to push the conference of this case out until next year. And the hope, I believe, was that Kamala would ultimately win the election And then there could be potential changes at the Supreme Court level, maybe new justices if Thomas and Alito or someone else step down. However, as we all know, Trump won, and the Supreme Court makeup is probably not going to swing anytime soon. It's going to be not favorable to the anti-gunners. It's probably going to stay very pro-2A, and none of those judges are going to really change. If Thomas and Alito decide that they want to step down, or if Sotomayor decides that she wants to step down, you're going to get pro-2A judges that are going to fill those positions. So that whole strategy to delay this case kind of backfired. And now the deadline for the state of Maryland to file the response has hit, and the state of Maryland has filed their response. In this response, the state of Maryland argues that this law is consistent with the text of the Second Amendment and also the Supreme Court's ruling in Bruen. They also argue that the Supreme Court should not review this case, should not grant the review of this, and simply they argue that there is not a conflict enough at the circuit court level down below to warrant review at this time from the Supreme Court. In their response, the state of Maryland frames the question presented to the Supreme Court as, should this court decline the grant certiorari to consider the constitutionality of Maryland's assault weapon ban, where 1, that ban is consistent with this court's recognition in Heller that jurisdictions may ban weapons that are most useful in military service, M16 rifles and the like. 2, the Fourth Circuit faithfully applied Bruen to conclude that Maryland's law is consistent with the nation's historical tradition of regulating those weapons that were invented for offensive purposes and were ultimately proven to pose exceptional dangers to innocent civilians. And 3, there is no need to resolve a conflict among the lower courts. So there, Maryland is doing some very interesting twisting of this case and the question that it should be presented to the Supreme Court for whether or not they're going to grant review to this case. The state goes on to argue in the response that this court's decision in Bruen left intact the pronouncement in Heller that M16 rifles and the like are weapons that may be banned. Nonetheless, this court vacated an earlier appellate decision in this case and remanded for consideration in light of Bruen. The en banc Fourth Circuit in turn reaffirmed the principles set forth in Heller and held that assault weapons covered by Maryland's law fell outside the Second Amendment's protection because, like M16s, they are militaristic weapons that are ill-suited for self-defense. And in accordance with Bruen's command, the Court of Appeals examined the relevant historical traditions and concluded that even if the weapons are protected under the text of the Second Amendment, Maryland's law is constitutional because it falls squarely within the strong tradition of regulating excessively dangerous weapons once it becomes clear that they are exacting an inordinate toll on public safety and societal well-being. The state of Maryland then concludes their response by arguing that even the Supreme Court agrees that this law in Maryland does violate the Second Amendment and is not in line with Bruen, they should simply still not review this case because there is not a circuit split down below. They argue that the petition identifies no persuasive reason why this court should grant review. Petitioners point to no split among the circuits regarding the constitutionality of assault weapons prohibitions. Moreover, they cannot show either that the Fourth Circuit's decision conflicts with this court's unambiguous statement in Heller regarding weapons that are most useful for military service, M16 rifles and the like, or that the Fourth Circuit's historical analysis departed from this court's pronouncements in Bruen and more recently Rahimi. To the contrary, the Fourth Circuit's decision is faithful to Heller, Bruen, and Rahimi. So that's some very interesting hardline positions that the state of Maryland is now taking in the response, and I don't think that those arguments and those positions are going to be taken favorably by some of the justices like Thomas and Alito. I don't think that they're going to appreciate that. The aim now is to have this case to be conferenced before the end of this year, and that would potentially get us an order of whether or not the Supreme Court is going to grant or deny review of this case before the end of this year. Again, I think the state of Maryland and a lot of these judges and a lot of these circuit courts and other cases were trying to stall the cases out in hopes that Trump would not win the election, that Kamala would be in place, and that the makeup of the Supreme Court and some of these circuit courts would kind of flip a little bit, but that has not played out, and now we're going to see a lot of cases moving forward, and I think we're going to have some very good pro-2A wins going forward, and I think this would be a perfect case for the Supreme Court to finally address this issue and finally say that these comprehensive bans are in fact unconstitutional, and for the Supreme Court to finally strike them down. So as things develop, I will let you guys know. If you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.